So imagine this proposition. Think about that your life has ended and you're looking down from your cloud at those below, your loved ones below. Hopefully you're looking from up top versus any other alternative locations you might be at that time. So everything you're looking at tells you that your estate plan is working perfectly. What does that look like to you? What does that vision mean to you?
What do you think?
These are rhetorical.
No, really. What do you think?
Everything, your estate plan is working perfectly. Okay. Well, for me, that would mean that, and this is kind of a general question. Then we can go our answer. We can get specific. That your heirs are taken care of.
Mm-hmm. Absolutely. Anything else? Any?
You
have any thoughts?
Whatever you've saved over your lifetime went to them, and not toward other expenses.
There you go. Like taxes, long-term care, that sort of thing.
Right.
Absolutely.
So you're looking at making sure the people you care about get your stuff, and
yes,
at the lowest cost, presumably. Is that right?
Yes.
Mm-hmm. Yeah.
No surprises? All right.
What don't you want to see? Other than unnecessary expenses.
Yeah. That something that could have been executed properly wasn't.
Right.
While you were alive. That something your plan you thought was well thought out, well put together, but
Right, exactly.
somebody missed something, and and hopefully not the professional you paid to help you put your plan together.
Well,
That is correct.
absolutely.
Welcome. Hi, good to see you.
Sorry, we're late.
That's all
No
right.
problem.
So, all that being true,
Still on the first slide, so you're in good shape.
that's right. We're just on the first slide. So everything you said is true. So with that in mind, and we all agree that what we said makes sense, why then, in our experience, do most estate plans not work effectively? And that sounds a little strange, perhaps, when we say, why don't most estate plans work?
Yeah, Rich, I have a will, and a lawyer did it for me.
Right. Yep.
Right. And here's the real problem. We think about the success or failure of a estate plan typically in the immediate aftermath of someone's death. Now, there are plenty of cases where we know right off the bat things are a problem, right? People are already fighting and doing all these other things. But sometimes we don't know whether our plan really succeeded or failed for years, months, years, or decades later. Because here's an example. Husband and wife, they own assets typically in what form of ownership?
Home.
No, how do they own it? Jointly, right? Joint tends to right of survivorship. Because it's a natural assumption that you pass away, he's going to get it. Or actually, he's going to pass away first and you're going to get it. We always call it the husband first in our conversations.
Yeah.
Right. So, isn't that a fair assumption, right? But what could happen, if you have children, what could happen that something that she may or may not do that ends up the assets not going to the kids? What kind of things can happen to her? And this goes to any married couple, not picking on you personally.
Wait, you're talking about the surviving?
Yes.
What could the surviving spouse do, or what could happen to them that might screw the plan up a little bit?
We die at the same time.
Perhaps.
True.
But let's say you do outlive.
Marriage?
All right, a remarriage case, right? Someone remarriage. You're on your cloud. That's what we just had that proposition. You're looking down from your cloud at what she's doing. And she remarries. You're saying, don't do that, right? But she does it anyway. She can't really hear you at this point.
Yeah.
She says, don't do that. But she does. And what happens then? What happens if she dies first? Perhaps. Where the assets go? No, he's gone already.
The new husband.
The new husband might get them.
Yeah.
Even if she has a will that says everything goes to the kids, your husband can exercise what's known as a spousal right of election and take a third of the property. All right? Let's say, though, there's never remarriage, not an issue. What happens you get older? What happens to older people sometimes? They wind up in a nursing home, is the comment, right?
Or any kind
So
of long-term
this could
care.
be 10, 20, 30 years even after the husband's death. The wife then needs long-term care.
Yeah.
If proper planning wasn't done, then we have a scenario where the assets are not protected and may not get to your ultimate heirs.
Does anybody know here how
Why
much?
wouldn't they be protected?
You know how much a nursing home costs per month in Orange
Okay.
County, roughly?
So that's it, right, okay.
Yep.
So you say why? The question was why wouldn't they be protected? Well, the answer is, remember, we had everything joint ownership. After the first spouse's death, nothing legally had to be done at that time. Everything passed to the surviving spouse. Sounds on the surface like a perfect plan.
Right.
But
Yeah.
we see the end result of things that don't occur, that don't end up in the way we want them to go. And the result was unintended because the consequences were not articulated at the time the people were doing whatever planning they did.
Yeah, so it's really, the theme here is really trying to anticipate, not necessarily they have a crystal ball, but planning far ahead.
Knowing
as possible.
Any scenario.
as many scenarios as we
many
possibly
as
can
we
think
probably
about,
can.
and as many options as you have. Right.
But it could be endless. Could you just go back to your example okay, so the husband passes away, the wife survives, the will is intact, she remarries, but nothing is redone with the will. So why is the second spouse entitled to this right of election?
Under New York law, they say that
Whether
any
their name
spouse,
is
under New York law,
or not.
they
Or
say
the will
that
or not.
a spouse is entitled to a third of your estate, roughly. Yeah.
In all
whether
states.
they don't have to be named in the will.
Not
Correct.
at all.
So
In fact, it can
in
say,
virtue of being married.
it can say in the will specifically, I leave nothing to my husband, Shecky Green. Nothing goes there. However, by law, Shecky can come to a lawyer and say, I want my third. Or Mr. Lawyer, can you tell me, am I entitled to anything under my wife's estate, even though she says in her will I get nothing?
Right.
The lawyer, if they know what they're doing, will say, oh, yes, you can take your elective share.
Right.
And every
Actually,
state has
okay.
that.
Shouldn't, as a reputable attorney, or that woman herself, if she remarries, shouldn't
She should absolutely
imagine
update her
to
planning,
redo-
but we can't go and force her to
will?
do that. Right.
Right, but she would be well advised to do that.
Of course.
Okay.
Right, or do a prenuptial agreement.
But do we want to wait for her to maybe do that, or do we want to
Or
make
wait
sure
for
we're thinking about it
something to
now?
happen to her, which is what you postulated.
Right. And we'll talk about other examples of things that maybe aren't thought about in advance that become unintended consequences regarding your kids or things particularly. So we'll move ahead up from here. So we have a few smoke screens that sort of obscure effective estate planning in too many circumstances. The first one is the common will versus trust. We get calls all the time, oh, I need a will or I need a trust. That would be like us saying to someone coming to do work in our building, you know, I need you to use a particular, kind of tool that you have. Because these are just tools of our trade. Wills, trusts, powers of attorney are just tools of our trade. You know,
Right.
coming to you, I need you to use a certain kind of metal for doing installation of an HVAC system. Sounds silly on the surface, but that's no different than telling us what instrument you need to use. The real question is having a conversation, oh, our building is too hot, can you cool it off for us, right?
Yeah.
And you using your professional knowledge and expertise to accomplish that for us. Same thing here. You have to tell us, you generically as the client, what your concerns are, what your family structure constitutes, who are the key players in your world, what kind of assets you have, you know, how they're owned, and then we use our knowledge and expertise to advise you about the options you have for doing planning.
Yeah. Everybody calls up saying they want a will or they want a trust. Nobody actually wants a will or wants a trust. They want something to happen. They want they want that to get them somewhere. We need them to tell us where they want to go, and we can get them there with whatever document or documents is going to make sense.
You know, again, this may be one of those questions where we're going to get to it or whatever, but I was, historically, how have you seen the effect, say, in these phone calls that you get, of being able to literally log onto the internet and research so much? Do you find that people are maybe doing that and reading things and maybe are getting confused or not really understanding?
There was this great thing I saw online the other day, which said, don't confuse your Google search with my law degree. And I would add to that experience doing this for, with Rich,
Or
15 years, with me, 8 years. Right, you can look, I can get a ton of information online on quantum physics. That doesn't make me a scientist. And I do
have
look
you
at
seen that,
but,
the effects of that in the calls?
Oh, sure. Look, we've seen the effects of DIY estate planning all the time, and you know what? They're unfortunate. The kinds of money that's lost when someone knows or thinks they know what they're doing or are trying to, let's be honest, what they're trying to do is not spend money on a lawyer. Okay? We know that. We're not dumb. But then they end up spending more money on taxes, spending a heck of a lot of money on a nursing home, having litigation arise because they meant to do one thing, but it didn't really work, and their kid says, well, this is what they meant to do, but it didn't really happen, so the other, all those things, but at the end of the day,
Have
Look,
you
I'm
seen
not
a
gonna-
lot of that
I-
too?
you know.
Yeah, but and that being said, we certainly wouldn't discourage people from getting educated. This is the purpose of having a workshop that we do every month.
Oh,
We'd
yeah.
rather have people come and hear this and read the articles and even read stuff online and so on, and yet and then come in with a little bit more information. But don't assume you're ever going to learn as much as we do, or else we're in the wrong business and you should be doing what we do.
And that does happen on a regular basis. Clients will come in and say, hey, I saw this article, or I saw this, and we'll talk about it. You know, we'll say, oh, okay, here's what that means, and here's how that plays in for you, or that doesn't apply to you, or whatever.
Right. The second smoke screen is the avoid probate, save taxes conundrum. People have this ingrained concern about the probate process. First of all, a lot of people don't even know what probate is. Probate is simply the legal process by which a person's individually owned assets must be passed and administered through the court system, because obviously not obviously I shouldn't say that because a lot of people don't think it's obvious. If I own an account at a bank in my name alone, the fact that I'm married doesn't matter. My wife wouldn't have any legal control or access to that account after my death. If it was a joint owned account, that would be different, but that has its own set of pitfalls that we've already touched upon. However, so who can gain access and how can they do it to my bank account? Someone is going to end up with it ultimately, the money in that account. That's where the probate process kicks in. Someone has to apply for letters of either administration or letters testamentary at the time after my death. If I have a will, they can bring the will to the probate court, the surrogates court here in Goshen, and file that. And if there aren't any complications, the letters of administration can be handled very simply. But a lot of people, for understandable reasons, don't want to go through that process. It is a court process. There are filing fees, and they're afraid they're going to have to pay a lot in legal fees, which may or may not be the case. So they do a lot of things to avoid probate, which sort of ends up cutting your nose to spite your face in many circumstances. So, for example,
idea is that,
go ahead. Yeah.
You know, when we talk about wills versus trusts, certainly avoiding probate, saving taxes. Look, in most of our planning, do we seek to avoid probate? Yes. In most of our planning, are we looking to avoid taxes? Of course. But it's a many-faceted question, and we all have to keep everything in mind, rather than the only thing I'm worried about is avoiding probate. Because if that's the only thing you're worried about, you might, like Rich said, cut your nose off to spite your face. You might have avoided probate, but then you might be spending hundreds of thousands of dollars on a nursing home or something like that.
Or Shecky Green gets the money instead of your kids.
Right.
Yeah. You can't be monitored, you can't just have blinders on.
Right. So the way we explain, as you're, I'm sure, getting a sense for, we have a fairly distinctive way of wanting to approach these things. And the best way to explain it, I think, is to first explain what I call the old way, or the, you know, maybe the traditional way, but not traditional in a good way, like the outdated way. And we sort of touched upon this already. Like a client would tell the lawyer what tools to use, like I need a will. You know, instead of calling and saying, this is what I'm concerned about, how do I get there? A general practitioner, now disclaimer about general practitioners, look, Rich's dad was a general practitioner, my grandfather was a general practitioner. We do work with a lot of attorneys that are general practitioners. They're often very trustworthy, you know, great friends of the family, or
pillars of the community.
Pillars of the community, you know, like great people. The issue is that in this area, if you're doing a real estate closing in the morning, then doing a DUI in the afternoon, then the next day you're doing something else, doing someone's will, if you're spreading yourself too thin, essentially, and there's too much specialization in this area. So, you know, I've seen this, unfortunately, and it used to happen a lot more, but it still happens quite a bit today. In fact, it happened in my own family. A general practitioner will prepare a will. And when I put prepare in those scare quotes, the idea is they're just plugging names into a computer. Now, here's a big secret. We have computers too, right? And we don't start from scratch every time either. We don't plug names into documents. It's a little more sophisticated than that. But at the end of the day, this attorney in this case, they're not really having a long, detailed, informed conversation with their client about what the client's options are, what the client's goals are. Part of our job is to be a little bit Socratic with you. You might tell me your goal is one thing, and I try to help you flesh that out because I know how these things can play out because I deal with it every day. But that doesn't really happen here. It's kind of in the second point here, or the third point.
Right, so you'll see here, you won't get that question. Well, what happens if, your wife remarries or needs a nursing home? They're not thinking, 6 steps ahead. That's really the biggest deficiency that we see in sort of the general practitioner mode.
Right. And at the end of the day, they're charging their client for what essentially boils down to word processing, which isn't a lot of money, but there's almost zero value there anyway. And the fourth bullet here, there have been trusted estate specialist attorneys for decades now, but they really were more tax focused. People would focus in the area of trusted estates because of the estate taxes and certain things like that. And a lot of times if an attorney had that level of education or expertise, they might be trying to recommend fancier kind of tools where a client wouldn't necessarily really need that. I had a woman come into a workshop like this once, and during the break, she mentioned, oh, it was a CPA in this case. She said, my CPA, my accountant recommended something called a QPER, a Qualified Personal Residency Trust. Now, that's the kind of thing you might want to be looking at if your estate, if you're an individual, is about over 5 million, or if you're married, your combined estates are over about 11 million. We'll get into the specific numbers in a little bit. So I said to this woman, oh, okay, so this is your rough, estate worth? And she laughed at me. She said, no, I don't nearly have that much. She had maybe like $800,000, something like that. And I said, then I'm not going to bother you. I'm not going to waste your time with a QPER. Have I done them? Do I do them? Yes. But, I'm not going to try to regale you with what I know about QPERs if it just doesn't apply to you. Why would we bother talking about it? So while people have specialized in this area, oftentimes they can miss the forest for the trees. They get too bogged down with technical parts of planning without keeping real world, real person stuff in mind. Okay.
So let's talk a little bit about the philosophy of an estate plan from a definitional and a standpoint. So here's how we approach it. First of all, the first fundamental precept is I want to control my property while I'm alive and well. Everyone wants to control it. There are different ways to control it in a way that can be protective for you, for your kids, your spouses, and so on. And we're going to talk more about that in general. But everyone, I think, starts from that idea, I want to control my property.
I think, and the reason we spell it out, too, is that I think people sort of take that for granted. I mean, while we're alive and well, of course, we want to control it. But when you're doing protective planning and things like that, we don't want to lose sight of that. We want to do planning in such a way where you're maintaining as much control as possible.
Right. The second point is I want to plan for me and my loved ones in case I become disabled. We think about estate planning all too often, unfortunately, only as death planning. But a lot of the planning results, good and bad, are derived by what happens and what mechanisms are in place to deal with incapacity or disability. So we're going to spend some time on that too.
One of the things I've started saying quite a bit is the question used to be, the reason people say I need a will is because the question always used to be, what's going to happen to my stuff when I die? The question is shifting now because of rising long-term care costs, because a nursing home could cost $12,000, $13,000 a month. There's one in Riverdale that's $28,000 a month. The question isn't what's going to happen to my stuff when I die. The question is, am I going to have anything when I die?
And the other thing is with longevity, we're living longer, but not necessarily better. 40 years ago, life expectancy was probably under 70 years of age. Now people are living, dozens and dozens of people a day are living past 100.
I got a client turning 105 in a couple months, I think it is.
Yeah.
Or maybe this month.
So we have to shift our focus and continually so into how we deal with incapacity. The third bullet point, or third point, is I want to give what I want, when I want, to whom I want, the way I want. What I have, what I want typically is what I have, my stuff, my assets. When I want, well, most people are thinking about after death, but you certainly can do lifetime gifts, and we'll spend a few moments talking about gifting.
Or transfers, not when you die, but years after that. Depending.
That's true.
Again, it's all
to whom I want, that could be spouse, could be children, could be other family members, could be friends, could be charities, or all the
season of giving, could be
all
charity.
the above, exactly. And the way I want. Now, this is the one that sort of is a fundamental difference from the way we approach it, or the discussion, than what I think the average planning scenario takes place, because most people assume they're just going to give to their kids, we're thinking about outright distributions. My kids, as long as they're not children, whether they're 21 or 51 or 81, they're just going to get their stuff. And on the surface, that's an appealing thing, and certainly from the children's perspective, they think that sounds pretty good. Oh, I want to get my stuff. But there's a lot of risks with taking an outright distribution where we can have protections. And what are some of the risks that we're talking about? What happens to adult children that is not always a good thing? What kind of legal process that they may engage in?
It happened to married adult children.
They
There
get
you go.
divorced, yes. We know the statistics, and it's quite frequent. So if people inherit property and it's in their own name, what do they, and they're married, where does the money usually go? What kind of an account? We talked about that earlier. Joint account. So what happens to that inherited money that was now in a joint account and the children get divorced? Guess who gets half of it?
Is that subject to that third joint, that 1/3?
This is different.
Spousal right of election?
No, because that's only if they survive as a married
Only if
spouse.
they survive,
Here we're
okay.
talking even worse, because most cases you're going to have a fairly equal split of the assets.
Yeah, no, but suppose that adult child who was gifted or left marries, and that person passes away.
Yes, I mean that's
Right.
partly true. Also, if they want to, the other thing is in talking about a non-outright distribution. What we're talking about is leaving it in a form of a trust for the adult child, because you can specify, well, as long as my son or daughter is married, that they can use and access the trust property as much as they want. But if they die before our daughter-in-law, we don't have anything against her. Maybe we do, but we don't. We want to make sure it goes to the grandkids. And in an outright distribution, that will not be guaranteed. So these are all the scenarios that really talk about. So we're going to spend more time talking about the way we want to leave assets. The form of inheritance is very important to get it right. And the last piece is we want to make sure we're doing our planning at fully disclosed and controlled costs to not only me, but those I love. Because a lot of the costs of estate planning aren't traditionally known while you're alive. That's what happens when you die. The kids will go see the lawyer, and the lawyer says it's going to be X dollars or X dollars per hour or a flat percentage of the estate value. All these things are done in terms of the cost of administering an estate. And unfortunately, all too often, no one knows what the assets consist of, so we have to go through all kinds of forensic exercises to go find the bank accounts, and that increases the cost, increases the delay. What we'd rather do is know what we're going to pay right up front, not only during our lifetime, to maintain our plan, and to settle the estate when we die.
So you're saying you can actually know ahead of time? You can control it?
Yes.
That way you can know ahead of time?
Yes,
With our process, you can.
that's right. So that's all important.